Okay, so we do have an ordinance that will be read with this as well, and this is ordinance 2017-10. 2017-10, an ordinance of the City of Moscow, Idaho, a municipal corporation of the State of Idaho, amending ordinance number 2016-11, the appropriation ordinance for the fiscal year beginning October 1, 2016 and ending September 30, 2017, to appropriate monies in the sum of $75,018,649, providing for this ordinance to be in full force and effect from and after its passage, approval, and publication according to law.
Thank you, Your Honor.
With that, we will move on to item number 8, which is the legal briefing that regarding New St. Andrews College CUP appeals, and this will be Rod Hall, our city attorney, will be explaining this to us. Thank you, Rod.
Thank you, Your Honor. Council members, tonight I'm here before you because the city has received 2 appeals subsequently following the July 18, 2017 remand hearing that this council remanded back to the Board of Adjustment. We've gone through the whole process. Underneath our city ordinance, we have a process to how to process conditional use permits. This Board of Adjustment has been granted the authority that was delegated by this body to hear and make those decisions concerning CUPs and variances and a few other things that they're allowed to by law. Pursuant to our city ordinance, we have standards for how hearings are supposed to be conducted. The Board of Adjustment conducted their hearings pursuant to that, and after they met their original decision back in April 25th and was adopted on the 1st of May, there were 5 appeals that were sent to the City Council, which is allowed under City Code. Council heard those appeals at their June 5th, 2017 City Council meeting. All these hearings have been publicly and properly noticed. And out of those 5 appeals, the council sustained 1 and denied 4. The council remanded the decision back to the Board of Adjustment with specific instructions to open up the public hearing only to hear or to allow more information concerning the parking survey. The council specifically wanted information relating to 12:30 p.m. parking. I think before it just had 9 o'clock in the morning and at 3 o'clock in the afternoon. City staff presented that information to the Board of Adjustment, and then they closed the public hearing portion of it. No more public information was allowed. Public testimony was allowed back at the April 25th public hearing when, pursuant to Idaho Code, State Code, there was an opportunity for people to a meaningful time to be heard. They had an opportunity to come in and speak in favor of or against, or if they just wanted to have a comment in the record. At the April 25th hearing, the public input portion closed. Now, this is not your regular legislative hearing. This is part of the quasi-judicial hearing, which we talked about earlier tonight. You guys were acting like judges. The Board of Decision was the original body. You were the appellate body for them. When those appeals came to you, you heard the appeals, and just based on the merits in there, you returned 1 back to the Board of Adjustment. Board of Adjustment properly noticed that hearing and conducted another hearing with the instructions that council had provided. They made their decision. They upheld the CUP for the NSA, and they reduced the area for the required parking mitigation that was required under the CUP. Based upon the information that was presented all throughout the record, they brought it back from like a half a mile to within a quarter a mile. Because I think most of the argument was that if it was a half a mile, if they were talking about students, they wouldn't be using the parking lot, and then they would be impacting the on-street parking. Most of the discussion talked about if they brought it down within a quarter mile, they'd be more likely to use it and would be lessening the impact of public parking on the streets. At this point, these 2 appeals that are before you, I'm not sure, there's no process under our city code for them how to do that. The only thing at that point, if somebody wanted to appeal to district court, they would have a burden that they would have to meet under the statute. I believe this body could take a look at those. It's the same thing as if it went to a district court, and if there's some clear errors in the record or violation of somebody's substantial due process rights, that I think this body could grant extra due process or extrajudicial process to correct any of those glaring errors. But I think they're very specific at this point in the process. Has it narrowed down at the remand? It was just remanded back just for one specific reason, basically, to add additional information concerning the parking. And also you asked the Board of Adjustment to consider criteria number 4 and number 7, which is did, and they've rendered a decision. So today, I would think that this body could review the same as the district court would, and under would be the Idaho Administrative Procedure Act, which is allowed under the Local Land Use Planning Act under state code. And you can look at the scope of review under Idaho Code 675279, which was provided to you. And it's very limited on what you can do, what your court would have to find. We had 2 appeals, and I'll just briefly go through them. Start with first, we had an appeal from an Ian von Lindern and a Margaret von Braun, who have a business at 121 South Jackson, I believe, is the address. One of their first complaints was that they did not receive legal notice, or they didn't receive notice of the process. In the packet, I provided you everything that the city did to make sure that everyone got proper notice. City code or state code requires on these type of actions that people within 300 feet are required to get mailed notice. Our city code expands it even farther. We're required to provide 600, which is 300 more than what the state did. Looking at what the Board of Adjustment or the Community Development did, they provided notice to these proper addresses. They made proper mailing at the proper time, and then they have a process for if mail gets returned. When they reviewed their process, there was nothing that was returned stating that somebody did not get their mail. So there was nothing that alarmed them. So under the first one, it appears that legal notice was provided.
If I may, Mr. Mayor.
Walter?
You're talking about notice for both Board of Adjustment hearings.
Yes, for all the proceedings. They claimed that they didn't get the first one mainly.
So they were notified, you're contending they got notified for everything that occurred, and they're saying they got nothing. Is that correct?
They said that they didn't receive the mail there.
Okay.
I think they said something that the Latah County tax assessor, they send a notice to their personal residents, and I think that's more of a convenience. What the city does is we look at the property owners, and if anybody purchases a property, that it gets put into the system from the county, and we use that information to make the legal notices. And that's the way the city always does. Every city does it that way. So then, if you're looking at that appeal, their question is that they didn't get notice. The facts of there shows that they did get notice, legal notice anyway. Then also in that appeal, there's at least another procedural error that they would like to bring forward. They're saying that our city code is in conformance with state code. They're saying that if the city is going to provide appeals, that the time period needs to be at least 14 days. City code, the time to appeal was 10 days from April 25th, which was the time to appeal here. They're saying that somehow our process is wrong. But I think they misapplied or misunderstood the law that they were talking about. The code that they particularly talked about was stating under the Board of Adjustment decisions, all final decisions are to be in writing. The reason for that is if a reviewing body is to review a decision, they need to have something in writing. If the deciding body failed to put it in writing, somebody who would like to go to district court must first go back to that body and ask them for reconsideration, basically to ask them to put it in writing. And if they don't exercise that, then they're not allowed to get into district court, because the idea is if it's going to be reviewed, the court wants to see it in writing. If it wasn't in writing, they would go back and they ask them within 14 days to put it in writing. They don't, then they could go to district court, and district court would automatically say, yes, that decision needs to be in writing. The Board of Adjustment actually put their remand decision is in writing, and that is part of the record.
Walter?
Again, Mr. Mayor, so our code reads 10 days to appeal. Did they meet the 10 days?
This appellant did not appeal until 10 days after the July 18th meeting of the Board of Adjustment on the remand.
But they did make the 10 days.
They put 10 days to appeal from that, but I'm saying that they had 10 days from the original hearing, April 25th, to appeal.
And they did not appeal.
They did not appeal, and they're saying they didn't get notice.
Okay.
And they're saying that that 10-day notice back then should have been 14 days. But the code section they're talking about to be in writing, the code specifically says this section. So that 14 days only applies to this particular section. The other part of the code talks about that if a municipality develops its own process and procedures, then these rules do not apply.
No, well, so what you're pertaining that to, Rod, is the Von Lindgren and the Von Braun appeal,
Correct.
That's what you're talking about in this. So I want to make sure, because there's two different issues, and so that's a different one.
They did not appeal the first Board of Adjustment decision at any time, within 14 days, within 10 days, or any time after that first decision.
No, the first time that they appealed was 10 days after the remand decision of July 18th, so we received it on the 31st. That's the first time they tried to participate.
Okay.
My contention is, based under the memo and the information I provided, that if the council finds that they were given proper legal notice and that our city code is not in violation of state code, that they don't have standing to proceed on any further issues. The time period to come forward and to be heard was at that public hearing back on April 25th.
If I may.
Okay.
So Rod, I believe Walter's question was pertaining to whether you utilize the 10 days or the 14-day yardstick. You're saying that they did not appeal within either 10 or 14 days of that original April hearing. Is that correct?
Yeah, they had not appealed at all. The first appeal was July 31st, 2017. Then he also had a couple of other, or that appellants had a couple of other things that I don't think this body needs to get to if they find that they've got notice and that the decision is writing, because their time to appeal lapsed 10 days after that April 25th hearing. But they did raise up the issue that they believe that the decision of the Board of Adjustment was not supported by any substantial evidence. They also said that it was arbitrary and capricious. And their last thing was that there was no justification or reason statement in the decision, and that the additional parking information that this council told the board to consider was substantial change in the decision, resulting in new conditions. But I don't think we get to that far. The other appellant was the successful appellant.
Could I ask you a question
Sure.
about the one, the Von Under and Von Braun one? So what you're saying is that because they weren't an original appellant, that they would have no if you weren't one of the original appellants that was remanded, you have no standing to appeal the remand decision, correct?
Under our city code, the process on the remand, if they didn't appeal, they're not part of the process. Otherwise, you'd have a process where people could appeal any time and then decisions would never ultimately be made.
Okay.
I just wanted to be clear about that wasn't because they didn't appeal in time the second time, they just had no standing to do so because they didn't appeal in the first place.
Yeah, they did not appeal to be a participant or a party to that appeal or that process.
Thank you.
Your Honor, if I may, I would suggest that the council treat these appeals totally separately, take a vote on the first appeal, and then proceed to the second appeal.
I agree, you can definitely do that. I was going to present that and say that there are two actions here, what they were doing, and talk about it.
Let's go ahead and talk about the second one then, because you were getting ready to start on that, and then we'll come back to this, because there is two issues here that the council's going to have to determine. And then I got a couple of questions that I want, a couple of timelines that I want to point out before I go to council on this as well. So why don't you go ahead and continue with that, Ron?